Welcome everyone to the week 8 tutorial on law, fact, and evidence. And we are now in week 8 of our unit. We only have about 4 weeks to go. And I'm very thankful to the students who are often, all who are consistently in attendance in the tutorials. So thanks for always being there, because it can get quite lonely if we only have a few students joining us. I'm glad you're always there. So tonight we'll talk about law, fact, and evidence. And before I do that, before we start talking about the topic, I just wanted to say something about the midterm assessment, and I've had a few students talking to me about their marks. The main problem often that students encounter in relation to case problems really has to do with being able to identify the legal issue. Because as I have indicated in the feedback that I gave, as well as in some instructions I gave in the past, the ability to identify the legal issue if you are faced with a case problem is very crucial, because the identification of the legal issue will mean that you are then in a position to identify the relevant legal rules. So if you misidentify the legal issue, chances are the legal rules that you will be discussing have nothing to do with the case problem, and they will be unhelpful in you arriving at a conclusion or in being able to provide legal advice. So for example, if the legal issue pertains to natural justice, and then you're unable to identify the legal issue, you simply say that the question, the legal issue is whether or not judicial review is available. That is a very broad legal issue. A good legal issue is one which says the legal issue is whether or not judicial review is available under the ADGR Act or maybe Section 39B of the Judiciary Act of 1903 on the ground that there is a breach of natural justice. So in that case, by pinpointing the particular concepts or themes that you are looking at, when you discuss the relevant rules, you'll only be talking about the ADGR Act or Section 39B of the Judiciary Act, and you will only be talking about natural justice. Now, if you fail to do that, and you simply say the legal issue is whether or not judicial review is available, the question is, what rules are you then going to be discussing? You'll end up talking about all possible grounds for judicial review. You'll probably be talking about the difference between the ADGR Act and the Judiciary Act of 1903. You'll probably be talking about legal standing, which probably is not even in controversy, because we know that the person has legal standing because his interests have been affected. So that is a crucial point. Now, as we move towards the end of the unit, what we're beginning to do is to delve deeper into particular grounds for judicial review. And in the final assessment, you will then be faced with a task of identifying the legal issue. You simply cannot say that the ground for judicial review can be based on a lack of evidence, or Wednesday unreasonableness, or failure to exercise a discretion as required by law, and so on, if it has nothing to do with the facts. So you need to be able to pinpoint the legal issue. And I'm going to be talking about this when I do the, the revision, I think in week 12. So that's just a reminder. Okay, so tonight we talk about law, fact, and evidence. This is an important topic again, because if we go back to the basic postulate about judicial review, we know that judicial review is limited and narrow, mainly because, apart from the fact that courts exercising judicial review are unable to substitute their own decision for that of the original decision maker. So mainly they can set aside or quash a decision, but they cannot remake a decision. It is also limited and narrow in the sense that judicial review is mainly focused on determining whether the decision is legal or not, or according to law. So the focus is on the legality of the decision. So therefore, questions about factual correctness, which is part of merits review, apart from the exercise of discretion, that can only be based on merits review. I'm looking at Jackson now. I'm just curious. Jackson looks like one of the well-known actors. What's his name? Jackson, do you know the name? I'm getting distracted.
No, this is just my annual leave.
You're probably on mute, Jackson.
I said this is just my annual leave look.
No, but there is an American actor, really well known, who looks like you. Yeah.
Oh, there's a doppelganger of me. Maybe it's, no, I don't know who it would be.
Yeah, exactly. Trying to figure out who that was, but there is that guy. When it comes to mind, I'll tell you. Okay, anyway.
Do I get extra marks now, or?
It's enough that you get the compliment.
Okay, no worries.
Okay. So, as I was saying, questions about factual correctness are mainly for a merit review to be determined. So, in other words, if an applicant is aggrieved by a decision based on a claim or an assertion that the decision is wrong because of an incorrect finding of facts, as a general rule, you cannot go to the courts for judicial review, because the general rule is that even if there is a grave factual error, and the grave factual error leads to injustice, let me be clear, let me repeat that. So the general rule is that even if there is a very grave factual error, and that grave factual error actually leads to an injustice, it is still beyond the power of the courts to undertake judicial review in order to correct the factual error, because that is simply for merits review to undertake. Now, as we know, the problem with merit review is that if you're speaking of merit review by the AAT, the difficulty there is that you can only have a merit review by the Administrative Appeals Tribunal under the Administrative Appeals Tribunal Act of 1975 Commonwealth if one of the administrative decision is made under an enactment, and that particular enactment must provide that an applicant can ask for a review by the AAT. So those are the two minimum requirements. So in other words, if the decision is based on the exercise of the inherent powers of the executive, you can never have recourse to the AAT. And even if the decision is made under an enactment, but the enactment does not provide for the availability of review by the AAT, then you cannot have merit review. So ultimately, therefore, your fallback is to determine whether or not you can perhaps seek judicial review. So going back to the issue, therefore, of law, fact, and evidence, in general, if there is a factual error, no matter how grievous, how grave or wrong, the decision might be because it is erroneous on the basis of the facts, you cannot seek judicial review in general, because a review of the facts of a case, usually, as we said, talks about the correctness of a decision. That is for merits review. However, we know that in common law, and as codified in Section 5 of the ADJR Act, we now know that the lack or absence of evidence is a ground for judicial review. So when there is no evidence to support the executive decision, that is a ground for judicial review, both under the common law and under the ADJR Act, particularly Section 5 of that particular statute. Now, it is not just about the fact that there is a misappreciation by the decision maker in relation to the decision, in relation to the facts. It is the absence of evidence. Okay, and we later see that. I think we're discussing it next week. We later see that there is a very strong link between the notions of an absence of evidence as also involving Wensbury and reasonableness, in the sense that when a decision maker makes a decision, when there is no evidence, then surely the decision would amount to Wensbury and reasonableness, because no reasonable person could arrive at that decision in the absence of evidence. So that's one. The second aspect as well, and I think we're looking at this in week 10, I think, is that it is also related to the idea of an error of law. So when there is no evidence, the lack of evidence or the absence of evidence actually amounts to an error of law. And we know that an error of law is always a ground for judicial review. Okay, so tonight, although in general we said that courts undertaking judicial review do not examine the factual correctness of executive decisions, there is an exception to the general rule, and that is when there is no evidence or there is an absence or lack of evidence in the executive decision. But it is important for us to examine this in detail because it doesn't seem to appear as simple as it seems. When do you know that there is an absence of evidence? So as we go through the discussion questions, I think I prepared 7 of them tonight, you will see that it's a bit more complex. It's in fact very, very complex. So tonight, after studying this topic, you should be able to discuss and explain no evidence as a ground for judicial review of common law, and no evidence as a ground for judicial review under the ADGR Act. Let me also point out that it's not just actually based on the common law, it's actually based on statutory law, not just the ADGR Act, meaning Section 39B of the Judiciary Act. It can also be based on Section 75.5 of the Australian Commonwealth Constitution, because it is possible, as we said, for a decision not to have been made under an enactment. So if that were to happen, you will have to examine your legal options in terms of seeking the issuance of writ of mandamus, prohibition, or injunction against an officer of the Commonwealth when there is no evidence that would perhaps support the decision of that executive. Okay, any questions so far or any comments before we continue? Questions, comments?
Yeah, I had one, Manjo. I don't know if you can hear me.
Yes, I could hear you.
Oh, okay. Going back, because I didn't get a chance to jump in at the beginning when you were talking about the midterm exam.
Yes.
I fully understood all of the reasoning and the answers that you gave on my paper, as I'm sure many others did, because we did natural justice in week 7. The bit of an umbrage that I took with the way it was marked was that we didn't actually do anything about natural justice until week 7, and yet the paper was released only at the time where we completed up until week 5, which was unauthorised decision making. We had done some foundational concepts of judicial review, but there was nothing major in there about natural justice, which is why I think a lot of us just put down the fact that we would move this way or that way. It didn't go into the actual sections of the Act.
Okay, fair point. What we need to remember, in fact, is that the grounds for judicial review, including the breach of natural justice, is actually covered in week 2. It is covered in week 2, and we covered it as we talked in greater detail about judicial review in week 3 as well. So it is a foundational concept. Now, the issue about the lack of natural justice, for example, the failure to the rule about the prior hearing, the requirement for a prior hearing, that's not a very complex topic. We noticed that when we went through the discussion on natural justice last week on natural justice, it was actually more complex, especially when you talk about the no bias rule. That was the complexity there. But the idea that you should be given an opportunity to be heard, I think it is something that a lot of people would quickly pick on. And in fact, the reality is, majority of the students, about 90% of the students, did pick up on the topic on natural justice. So we talked about natural justice in weeks 2 and 3, and in fact across most weeks prior to week 6. But we then examined it in detail in week 7. But that is not to say that we did not discuss natural justice, because we did. It is covered in weeks 2 and 3. In fact, it might even be covered in week 1. Okay, so that's the explanation I made. Most students did know that there was a violation of natural justice. They were in fact able to identify that, and we did discuss that in weeks 1, 2, 3, and 4. I just noticed here a remark coming from Michael. Where are the remarks, as I cannot see any? They are in fact turn in. So, very good. So I don't know how your Moodle page looks like. It could appear that mine is different, but from coming from Sarah, if you click on your percentage, it will take you into turn in. Then in the column on the right hand side, you'll see it. So mine is probably different because I have grade mark and I have original mark, which you probably don't have. So, but anyway, I had about 5 students who asked for a PDF or a copy of their feedback, which I was able to send. But otherwise, you should be able to find a way to be able to access the feedback, because I did provide extensive feedback to each of the papers that was submitted.
In regards to that, Manjo, I was going to say, when you open it and you're reviewing the feedback, and you've got the feedback in the column on the right-hand side, if you go up to save and go save as PDF, it will save it as a PDF with all of the comments stretched out at the bottom, and it's really easy to read because everything's in order then, including all the little comments you put in the little blue boxes through paper. It's all laid out to the bottom of the PDF.
Yeah. So I don't know how to look. I don't know how it looks from your end. So that's my difficulty there. But I think the suggestion of Sarah and what you pointed out, Nicholas, should be helpful to people like Michael and those who seem to be unfamiliar with trying to access the feedback that I gave.
Yeah, that was my only comment about the feedback, was that it was very in depth, and I'm appreciative of the fact that it was in depth, Manjo. There's no question about that. But I think it was in depth up to the level of week 7, and that was where my confusion was when I was reading over some of it, because I was trying to just tame it back to the first 5 weeks of what we'd learned.
Interesting. Okay, that seems to be a fair enough point. Yep. But as I pointed out, I acknowledge that, but national justice was a common theme in weeks 1 to 3. It kept on emerging, especially in the discussion questions, but also in the textbook as well as in the discussion notes, because it is a ground for judicial review. Okay, so we could probably move on because thank you for that, Nicholas. We should probably move on because I've got 7 questions that I'd like to cover. Because the rules require that I cannot reassess on the basis of what had been assessed in the past. I can only ask questions on the basis of the week 6 to 11 topics. So I will certainly be asking a question on the no evidence rule. So I need to discuss this with you. So can we go through this? You might be familiar with, when you look at this fact, you'll probably see some resemblance in what had happened with the Department of Immigration. Was it last year when the chief executive officer there was accused of having committed sexual harassment or something? So I thought it'll be interesting to come up with a story that's similar to it, but not really that accurate. Okay, can I get somebody to read problem 1 for us? And this is the quiz question. Can I get somebody to read problem 1?
Angel, I'll have a go.
Thank you, Jackson.
Roman Quadson, a top executive of a federal government agency, was dismissed from service after an investigation and internal disciplinary hearing determined that he had engaged in an inappropriate relationship with a female staff member. The dismissal of Quadson was not based on statute, but on the exercise of the inherent executive powers of his superiors at the federal government agency. Responding to a newspaper reporter's question about his dismissal, Quadson said, "I am the victim of scandalmongers who want my job. I now look forward to exonerating myself from the allegations which are false, malicious, and incorrect. I can assure you that I have not done anything inappropriate." Quadson has come to you, a solicitor, for legal advice. He wants to know if he can apply for judicial review of his dismissal from government service on account of what he claims to be an incorrect finding of facts. He asserts that whilst he agrees that there is some evidence that he had engaged in an inappropriate relationship with a female staff member, the evidence is very weak.
Thank you. Can you see the choices there?
Oh, there we go. It's changed now. Problem 1. So which of the following statements is the most correct? So A, where there is an incorrect finding of facts, this results in the findings of the decision being contrary to law, hence a judicial review is available. B, Quadson can apply for judicial review under the administrative decisions Judicial Review Act of 1977, Commonwealth. Under the facts, Quadson has recourse to the Administrative Appeals Tribunal in an application for merit review. D, if it can be established that the Internal Disciplinary Committee made an incorrect finding of facts, then Quad runs, his name's changed there, by the way, right to natural justice was breached and he can apply for judicial review. And E, all of the answers are wrong. And I obviously don't have to answer this one because I picked up the spelling error.
Okay. Okay, thank you. Can I ask all of you to try to post your answer in the chat box? So Michael has provided an answer. Interesting. Okay. So we've got 5 students answering letter C. 1, 2, 3, 4. It's actually 4. Somebody has answered E. Another one has answered D. How about the others? C. From Jackson, we now have 5. What do the others say? Okay, Nancy has said it's a D. Just a guess. What do the others say? Okay, so maybe, it's about time we discuss the question. Who would like to provide an explanation as to why C to you is the most correct answer? The most popular answer is C, then followed by D, and then the least popular is letter E. Because we only have one student answering letter E, and that's Sarah Rogers. Why do you think it's the letter C? Or maybe we should listen. Yes, Nicholas.
Yeah, I was just going to say C, because as a general rule, judicial review is limited, and we know it's pretty narrow, and it doesn't examine administrative decisions or matters of evidence or facts.
That's right. I see. Sarah, do you suppose you could tell us why you thought the answer was the letter E?
Okay. Well, I thought it was E because I didn't think it could go to the ATT because the decision wasn't made under a statute. Equally, I didn't think it could go to the Administrative Decisions Judicial Review Act because it wasn't under a statute. So those two are out of the question. Then the other two can be summarised by the basic fact that I felt that judicial review was not about analysing facts, basically. It's about the legality, and therefore I felt that they were out of the equation then, because the common law rule is the fact that judicial review is legality, not factual.
So the correct answer is letter E. It's crucial to remember that as far as the jurisdiction of the AAT is concerned, there can only be merit review by the AAT if the decision is made under an enactment. And we know under the facts that it was based on, according to the facts, it was based on the exercise of the inherent executive powers of the superiors of the agency. So we know it was a decision that wasn't made under an enactment. That alone would tell us you cannot have merits review. And the second requirement, as you said, is that if there were to be merits review by the AAT, if a decision was made under an enactment, that particular enactment must also provide that merit review is available to the AAT. So those are the two requirements that are necessary. Okay, so are we clear about this? The answer is letter E. It also cannot be that, so as pointed out by Sarah, you can't have judicial review under the ADJR Act because it was non-statutory. The decision was made on the inherent exercise of executive powers. And we know as well that the incorrect findings of facts by itself does not amount to illegality of the decision. Now, so based on the facts in problem 1, what legal advice would you give Watson then? So the answer to problem 1 was E, none of the above, okay? So based on the facts in problem 1, what legal advice would you give Watson?
I would basically say that whilst judicial review on the basis of no evidence might not be available, perhaps he could look at if they have weak evidence, perhaps they've applied the wrong statute, the wrong test to the decision, or perhaps it's so unreasonable. You'd have to look at some other different ground basically there to say that they're acting outside of their jurisdiction, perhaps not within their powers. If that makes sense. Yep.
So if you look at the facts, what had happened here is that, so I'm not sure if you're seeing the screen now again, is that Watson actually admits that there is some evidence he had engaged in an inappropriate relationship with a female staff member, although he says the evidence is very weak. So we take that as a fact. There is evidence, but the evidence is weak. So the question is, does that amount to a lack or absence of evidence? The answer is no. So in other words, there is no ground for judicial review on the ground that there is a lack or an absence of evidence under common law. Under common law. So remember that the grounds for judicial review in relation to Section 39B of the Judiciary Act of 1903 come from the common law. So when you look at the grounds, you're looking at the common law. And we know that based on the common law, the mere fact that the evidence is weak is not the same as saying that there is no evidence. So here, you will have, if you were to be the solicitor, you will have to advise Watson that there is no ground for judicial review because there is evidence. Even if the evidence is weak, the mere fact that evidence is weak is not the same as saying that there is no evidence. And the requirement is for there to be judicial review under the common law, there has to be a lack or absence of evidence. Okay, so we're good.
So what
yes.
At the end of the day, he has no recourse at all, right? There's nothing he can do.
No recourse. You're stuck. There is no recourse. And if you're going to be the solicitor, you cannot advise to your client that he should apply for judicial review, because if there is no ground, you're going to lose the case. You will have a legal liability as a lawyer for providing the wrong legal advice. So he has no recourse. That's simply the way it is. There is no recourse. I'm going to read problem 3 just to make it quick, because this is short anyway. In Australian Broadcasting Tribunal versus 1, Chief Justice Mason said that Section 53B of the ADJR Act was directed to proof of the non-existence of a fact critical to the making of a decision. Okay. Now, in Carragh Queensland Mining Limited versus Daniel, Chief Justice Black in the federal court said that a decision may be flawed whatever the relative importance of the fact. And he said, if a decision is in truth based in the sense I have described on a particular fact for which there is no evidence and the fact does not exist, the decision is flawed, whatever the relative importance of the fact. The question is, was the decision of the full federal court in Carragh Queensland Mining Limited versus Daniel inconsistent with the statement of Chief Justice Mason of the High Court, Australian Broadcasting Tribunal versus 1? And what exactly are we talking about here? And why is that important? What do you think? So I'll probably be the one to answer that, or would anyone volunteer to answer the question? and to tell us, what's the whole point about this discussion. Because on the one hand, the High Court in ABT versus Bond talks about a fact that is critical to the making of a decision, critical. And yet we have a decision of the full federal court saying that even if the fact is unimportant, for as long as the decision was based on that unimportant fact, which in fact did not exist, then there can be a ground for judicial review on the ground of lack of evidence. So are those two the same? And why are we talking about these cases? Can I get some comments? If you know.
I can't quite wrap my head around it 100% yet, Manjo, because I haven't finished week's readings, to tell you the truth. I've been a little bit busy, but I'm getting the overview here that this is to do with the fact that the facts don't exist, and who is to prove that a fact does exist.
Okay. You're close. Others? Comments? So from Jackson, the section really confused. And it's true, it is confusing. This particular topic is very confusing. Now let's begin with this point, okay? When we speak of the Administrative Decisions Judicial Review Act of 1977 Commonwealth, what it essentially means is that a lot of the grounds for judicial review is a codification of the common law. Okay? Now, it is said that the ADJR Act is a major innovation in administrative law, mainly because by codifying, the common law, the decisions made by the courts, what it then enabled was, a handy way of finding out, is there a ground for judicial review? And then more importantly, as we see in week 10, we see that there are broader powers available to the courts if it is based on the ADJR Act. Because if you look at Section 39B of the Judiciary Act, or if you look at Section 75(5) of the Australian Commonwealth Constitution, the available remedies for judicial review are only limited to writs of mandamus, prohibition, and injunction. We see later on in week 10 that if you examine the common law judicial review remedies, they are actually difficult. The requirements are actually difficult to meet. We will see later on. So it was even said that the common law judicial review remedies, as we see in week 10, the requirements are so rigid, such that if one requirement or one element is not met, then you simply cannot have recourse to judicial review. But with the ADJR Act, for as long as you have a decision made under an enactment, and of course you have a person who has legal standing, and then you can identify a ground for judicial review, then you have recourse to judicial review under the ADJR Act. So it's easier. So in other words, if you're seeking judicial review, your first port of call should always be the ADJR Act, and you have to determine, is it available? Because if it is, you have to look at that. Okay, now, however, even as I said that the ADJR Act in a way codifies the common law, the problem is you'll notice that the ADJR Act has limitations. One of the limitations, as we said, was that the decision has to be based under an enactment. In particular, in relation to the no evidence rule, the other requirement is that in relation to the no evidence rule, under Section 5.1, as interpreted by Section 5.3 of the ADJR Act, there are two aspects. There are two ways of interpreting when there is no evidence. Okay, and that one of them is that there is a statutory requirement on the part of the executive or the decision maker to make a finding of fact. So sometimes there is a statutory requirement that you have to make a finding of fact on a particular point. Okay, and so that if there is a finding of fact on that particular point, but it wasn't done, then in that case, there would have been no evidence to support an essential statutory requirement. Okay, so that is one. But the other point is, if a decision, assuming there was no statutory requirement, but if a decision is made on a particular fact, but that particular fact, in fact, did not exist, again under Section 5.3 of the ADJR Act, then in that case, there would be a lack of evidence, and then you have a ground for judicial review. So what it tells us is that, let's assume that there is a decision that is made by the executive, okay? And we know that there is a finding of fact that is made. Let's assume there is a finding of fact that is made. And that finding of fact, there's actually no evidence to support the finding of fact, okay? Let's be clear about this. Let's assume a scenario where you have a decision made by an executive under an enactment, and that decision made a finding of fact, but there was no evidence to support the finding of fact. Are we clear? Question: can you apply for judicial review under the ADJR Act on the ground of no evidence? Was that question clear?
If there's no evidence and the fact does not exist, then they would be able to apply under 5.1H, subsection 5.3b.
Not that easy. Not that quickly, Sarah. Because the mere fact that there was a finding of fact, and in fact that finding of fact was not based on evidence, will not mean that there is no ground for judicial review. If you look at the case of ADT versus Bond, and you look at Cara Queensland Mining Limited versus Daniel, and looking in particular at Section 5.3.
It has to be a critical fact. It has to be a fact critical.
Critical fact. So in other words, the decision has to be based on that fact, and that fact actually did not exist. So if there had been a finding of fact, and the fact, there was in fact no evidence to support that finding of fact, but if that finding of fact was not critical to the decision, you cannot argue that there is a ground for judicial review. Was that distinction clear? So in other words, what it means is that for as long as a finding of fact was critical to the making of a decision, even if the finding of fact was unimportant, but it was critical to the making of the decision, and that finding of fact, there was in fact no evidence to support the finding of fact, then you have a ground for judicial review. But the mere fact alone that there is no evidence to support a finding of fact will not mean that you now have a ground for judicial review, because that finding of fact must have been critical to the making of a decision. Okay, now, on the other hand, if you look at Section 5.3a of the Judiciary Act, if there is a statutory requirement that a finding of fact has to be made, and there is no evidence to support, that particular finding of fact, the fact and the court and the decision maker fails to make a finding of fact, that then will invalidate, that will then mean that there is a ground for judicial review. So can you see the importance there? So what it means is that you can have, if you're speaking of the ADJR Act, okay, we're talking of ADJR Act, Section 5.1H, if you want to apply for judicial review on the ground of no evidence, the requirement is that there has to be a finding of fact that was critical to the making of a decision, and that there was no evidence, in fact, to make that finding of fact. But the mere allegation that there was a finding of fact and there was no evidence will not support an assertion that there is a ground for judicial review under the ADJR Act, particularly Section 5.3. Are we clear?
So just to reiterate, Manjo, going back to that first question where...
So, hang on, Nicola, sorry, before you forget, because I think there was somebody who said, can I begin to provide hints as to the kind of questions I'll be asking in the final assessment? I'll be asking a question about that. It's a bit complicated, I think, right? Is it? It is. But because we discussed it now, hopefully you should be in a position to answer it. Because I don't want the questions to be too easy for you, but at least you know now. You can make the distinction, right? Okay, Nicholas, go on.
Okay, just in regards to that first question then that we went over before, where we said that we had no legal recourse for ATT or judicial review. The reason he had no reason for a judicial review was because the evidence that was in play wasn't substantial enough. Is that along the same lines as what we're saying?
No. problem one was different because there was evidence. Although the claim was the evidence was weak or insufficient. So when there is evidence to support a decision, so we're saying there is a decision supported by evidence. So in other words, there is evidence, there is a finding of fact that on which the decision was based. So there is a finding of fact critical to the making of the decision, but the finding of fact or the evidence that was adduced based in problem one was actually weak or insufficient. That was the point there. The evidence was weak. But the mere fact that evidence is weak is not the same as a lack or absence of evidence. It's not the same. Okay? Now, problem three, the one we're facing now, is different because we are saying that there is no evidence in the making of the decision. That's the point there. However, the mere fact alone that there is no evidence to support, that there is a finding of fact, and there is in fact no evidence to support the finding of fact, will not mean that you now have a ground for jury review under the ADGR Act, because the requirement is that finding of fact must have been critical to the making of a decision, regardless of its importance. But it must have been critical to the making of the decision, and in fact, there is no evidence to support that finding of fact. So only if you have those two, that the decision was made based on a particular finding of fact, and that finding of fact was critical to the making of a decision, and in fact, there was no evidence to make that finding of fact. So only when you have those three, can you then assert that Section 5.3 of the ADGR Act applies. So that's why we're making that point, because not every instance of a decision based on an enactment where there is no evidence will mean that you have a ground for judicial review under the ADGR Act. So there is a limitation in the ADGR Act in relation to no evidence, the no evidence rule.
So in comparison, Manjo, it's actually, compared with the common law, it's actually harder to prove under the ADGR Act?
Yes.
Because, yeah.
Yep. So in other words, the hurdle concerning the ground for judicial review is higher if you're trying to seek judicial review under the ADGR Act. It is higher based on the rulings of the High Court and the full federal court, as well as the reading of Section 5.3 of the ADGR Act. So we're good. Okay, very good. So from Nicholas, Registrar versus the District Court, ex parte White, he said that even if the reasoning whereby the court reaches conclusion of fact were demonstrably unsound, this would not amount to error of law on the face of the record. Very good. Okay. So from Jackson is a question, can a finding of fact be made even if a respondent has not had an opportunity to respond to allegations? Would this be inconsistent with natural justice? There is a link. Good point, Jackson. There is a link, but they're not always related. There isn't always an overlap. What we need to remember is that the principle of natural justice will only arise if a decision by the executive will interfere or impair the rights or interests or status or legitimate expectations of a person. So if there is no right, then you cannot have natural justice. But the point is, oftentimes the executive does make findings of fact, will in fact arrive at decisions, such as when you apply, for example, for the first time for a business license, or apply perhaps for a license to become a Commonwealth, maybe a police officer in the federal police force. You don't have a right, you don't have an interest, you don't have a legitimate expectation in those instances. So natural justice will not arise, and in fact decisions will be made, and you will normally not be given an opportunity to be heard. So in other words, when you apply for a job, they're just gonna look at your CV, they probably look you up on the internet, and they see, oh, this person has done this and that. Then they make a decision. Was there a breach of natural justice? No, right? Because you don't have a right. And in fact, you can say that there was no evidence maybe to support a decision. So they're not always related. So can a finding of fact be made even if the respondent has not been given an opportunity to be heard? The answer is yes. So from David, does a failure to provide natural justice matter if there is a right to de novo review in another body, example review of RNS decision? Very good. there are two aspects to this, and thank you, David, for raising the point. Okay, the first point is that the courts have actually held, and this was something that was taken up in week 7, that even assuming that there has been a breach of the rules of natural justice, in other words, somebody was not given an opportunity to be heard, but if there is an opportunity for a review, in another body through a de novo review, then that will then address or remedy the problem of the breach of natural justice. So that's a good point. Okay, questions? Very good. Okay. This one, problem 4, this is a repetition of problem 1, so I'm not going to go through that because I wanted to cover questions 5, 6, and 7. I'm away 6:46, and some of you may have to go, so I'm going to skip this. The whole point about problem 4 is that there was an allegation of sexual abuse against somebody, and in the circumstances, under the facts, 8 witnesses said that there was no sexual harassment that happened, but the victim said she had been sexually harassed. Okay, we can even say that under the facts, 20 witnesses said it never happened, but the victim said it did. You remember the case of Justice of the U.S. Supreme Court, Kavanaugh. Do you remember that a few months back? Where there was a complainant who was a university professor, and she was saying that when they were in university, Justice Brett Kavanaugh had engaged in inappropriate sexual behavior against her. And the fraternity members of Justice Kavanaugh and friends said it never happened. But of course, the professor said it did. Now, if it had happened in Australia, for example, and let's assume that, in this circumstance, you have 20 witnesses saying it never happened, the victim said it did. And then the decision was made that believing the victim. So let's assume that the decision was made saying, sexual harassment has been established on the basis of the sole testimony of the victim, notwithstanding the fact that 20 others said it did not happen. Are we clear about the facts? The question is there a ground for judicial review on the ground of no evidence? That was actually the question here in problem 4. Can you assert that you can have a ground for judicial review on the ground of no evidence if under the facts 20 said it never happened, the victim said it did, and then the decision makers believed the lone testimony of the victim? Would that amount to the no evidence rule as a ground for judicial review? That's a question. What do you think? Yes or no?
I'd have to tentatively say no, Manjo, because there is all that evidence that's been produced.
That's right. So that's the crucial point there. For as long as there is evidence, even if the evidence is weak, and we can't even say that the evidence is weak. The victim, after all, made a statement. For as long as there is evidence, you cannot say that there is no evidence, because there is evidence, right? So there would have been no ground for judicial review on the basis of an absence or lack of evidence under the particular circumstance. So we're clear on that? Okay.
I can see a big mind map coming, Manjo, trying to map all this out in process.
Yeah, but it is helpful because, when you become a solicitor and you have a client, what you need to do is to begin to think of what exactly are the grounds. What can I do? Can I do this? Can I do that? It has to be all in the mind, right? So that's the advantage of knowing the law, because you don't have to, even if you were to do research, you know what to look for. But imagine if you didn't know these things, you wouldn't know where to begin, right? Okay, so let's move on because I've got 3 other problems. Okay, problem 5. Can I get somebody to just read problem 5 for us? Can I get somebody to read problem 5 for us?
Yeah, I'll do this one, Manjo, but I know Sarah's going to do the next one, so that's all right.
Okay.
All right. Manfred Brown, a top executive of a federal government agency, was dismissed from service after an investigation and internal disciplinary hearing found him guilty under the Work Safety Act Commonwealth of bullying Anwar Al-Amma, his subordinate. The Act provides that bullying is repeated verbal, physical, social, or psychological abuse by an employer, manager, or superior of an employee or subordinate at work. At the disciplinary hearing, 5 witnesses testified that during an office meeting in November, Brown had, in front of many other employees and managers, shouted at and made racist remarks against Al-Amma, who is of Middle Eastern descent. 2 witnesses testified that they witnessed Brown shouted at Al-Amma for over 5 minutes, but did not hear any racist remarks. Brown has come to you, a solicitor, for legal advice. What advice would you give him?
Good. So there is evidence. So can you just, if you could, this is going to be quick, can I just ask you to post in the chat box whether judicial review is available or not? So yes, judicial review is available. No. So just say yes or no. If it's yes, judicial review is available. No, it means it's not. Can I just get an answer there? Okay, so 3 have said no, because there is evidence. No, no. How about the others? There are 12 of you. For Michael, he doesn't see the difference from the previous question. Okay, fair enough. How about the others? Okay.
Basically, to me, how I'm seeing it, if someone makes a statement, that's evidence, and then therefore you got no review, full stop, done, you're screwed.
Okay.
So, I mean, because you're saying if one person says something, there's 10 people that say no. You know, and then you're saying there's no, here we're saying there's no comeback at all. And I mean, we've got 10 people saying something didn't happen and 1 said yes.
Yeah.
So,
Point.
you know, so you can say that evidence is to one person saying something, and that has to be a particular fact that's critical to the final decision.
Very good.
So wouldn't that then allow judicial review? This is coming back to the previous questions too, which then I go into a spiral of confusion.
There's actually a reason. Thank you for that, Michael. Was that Michael? I think it was.
Yeah, it was, yeah.
I couldn't see it clearly on my screen. There was actually a reason why I highlighted the word repeated. Okay, it's in the facts. Because the answer is actually yes, there is a ground for judicial review. Why is that? So we know there is evidence of abuse. There is no doubt about that. But I'm saying there is a ground for judicial review. Why?
Because the decision was made under an enactment and you need to follow the rules of the enactment.
Okay, go on. The reason why there is a ground for judicial review is because there is a jurisdictional fact that is required by the law. The jurisdictional fact is whether or not bullying happened, meaning it has to be repeated. Repeated means it can't just be once, it has to be at least twice. But the facts tell us it happened only once. So in other words, the jurisdictional fact of repeated abuse has not been established. And we know under Section 5.3 of the ADJR Act that when there is a jurisdictional fact that is required by law to be made, and there is no evidence that that jurisdictional fact exists, then in that case, there is a ground for judicial review. So my advice here would be that there is a ground for judicial review because a jurisdictional fact required by the enactment has not been met. There is no evidence of the existence of the jurisdictional fact, which was repeated verbal, physical, social abuse. So the answer is yes, there is a ground for judicial review.
Manjo, when we're talking about evidence here and we're talking about an investigation or an internal disciplinary hearing, obviously these people are then going out and questioning other people. Does that mean that you define the information that's being used as being on the record because someone's writing down the answers to the question compared to something that is just hearsay evidence where someone's telling a story to another.
That question, Nicholas, is different from the problem, I think, that we're posing here, right? So you're asking a different question. You're actually asking about the probative value of evidence. Okay. So again, probative value of evidence is not the same as evidence, because if the probative value, meaning the ability of an evidence to prove a fact, is weak, it doesn't mean, again, that there is no evidence. There is evidence, but you can question the probative value. That's not the same. Which is why in the examples we gave, there were allegations that the evidence was weak or evidence was insufficient, and we're looking at the probative value, therefore, of evidence in that particular instance. The fact alone that the probative value of evidence might be weak doesn't mean that there is no evidence. It's different, however, when, for example, I don't know when we discussed this, but it's different, for example, when the executive decision is based solely on speculation. I think we had that as an example in week 3 or 4. So when evidence is based purely on speculation, so let's say you allege that somebody committed theft, and the reason why you think that theft was committed is because he's driving a Porsche car or he has a mansion. That's speculation, right? That's speculative evidence. In that particular case, that speculative evidence will not be accepted. Okay, but hearsay evidence is different because remember, as far as executive decision makers are concerned, they are required to act judicially, but doesn't mean that they are judges. So we know by a review of judicial review, I think in week 2 or week 3, we know that administrative decision makers can make decisions based on hearsay evidence. Courts will never accept hearsay evidence. That's a violation of evidence. For those of you taking evidence, hearsay evidence is not permitted in courts, but executive decision makers are permitted to use hearsay evidence because it's still evidence. It's just hearsay. So I heard this person say this. That's hearsay, but that's still evidence. But speculative evidence is different because there simply is no evidence. You're simply speculating. Okay.
Yeah, what I was trying to get to, Manjo, was that it says at the disciplinary hearing, 5 witnesses testified during an office meeting. So that's what I'm saying. Are these witnesses in this case on the record because they're testifying what happened? So this is written down evidence. This is not just hearsay about what happened in the office.
It doesn't really matter whether it's recorded or not. The crucial point here is not so much the strength of the evidence of the witnesses. It's really whether or not the jurisdictional requirement on a particular fact has been met. Because here we have a situation where the enactment says that bullying must comprise of repeated abuse. So if you have a one-off incident, even if there's overwhelming evidence, 1,000 people saw that it happened, that cannot be bullying because the law defines bullying as repeated abuse.
Yeah, in this case, Manjo, what's distinguishing this example from the last one was the fact there was weak evidence on the last one, but there was no benchmark. But this one, because there's a jurisdictional fact, there is a benchmark of evidence that must be met. Therefore, because the evidence is weak and it doesn't meet this benchmark, then you can have the no evidence rule. And that's the distinction between the two problems that we've had.
That's right. So you can see it's a bit complex, right? The no evidence rule, not that easy. Now, it's 7. Are you prepared to continue? I've got 2 questions here to dig deep into the concepts. Are you happy?
Go, Manjo. I want everything I can from my mind map.
Okay, very good, very good. Now, this is a bit different. The facts seem the same, but they're not. Because here you will notice now, I did not say repeated. Okay? Can I just get somebody to read problem 6? And I think Nicholas was saying that after him, it's going to be Sarah Rogers reading the question.
That's fine. Unless everyone's sick of my voice, I do apologise. Okay. Manfred Brown, a top executive of a federal government agency, was dismissed from service after an investigation and an internal disciplinary hearing found him guilty under the Work Safety Act, Commonwealth, of bullying Anwar Olama, his subordinate. The Act provides that bullying is verbal, physical, social, or psychological abuse by an employer, manager, or superior of an employee or a subordinate at work. At the disciplinary hearing, 5 witnesses testified that during an office meeting in November, Brown had, in front of many other employees and managers, shouted at and made racist remarks against Olama, who is of Middle Eastern descent. 2 witnesses testified that they witnessed Brown shouted at Olama for over 5 minutes, but did not hear any racist remarks. Brown has come to you, a solicitor, for legal advice. He wants to know if he has grounds for judicial review.
Thank you. So yes or no? Yes, judicial review is available, or you would counsel judicial review, or no, you wouldn't advise judicial review. Yes or no? Can I just see some answers in the chat box? No. So we've got a student saying no, Jackson. How about the others? Ah, a lot of students have dropped out already. We've only got 8 left. Okay, that's fine. If you want to stay on, we'll continue. What did the others think? From Nancy, no, because there is evidence in this case meeting the jurisdictional requirement. The answer actually is yes, there is a ground for judicial review. And that is why, it can be very complicated. So perhaps in the final assessment, I will come up with a simpler answer. A simpler question. Because, yeah, I'll make it simpler. The reason...
Manjo, because reading that, and the Act provides that bullying is verbal, the first thing I would be doing is looking into that Act and qualifying what bullying as far as verbal is, because it's so open. I could literally just say a name and that would be verbal bullying, and that would be enough to get me dismissed. That's ridiculous.
That's a good point. That's in fact the answer there. There's a ground for judicial review because bullying can be a question of law. What exactly is bullying? That is not a question of fact. So what it tells us that sometimes what appears to be fact is actually a mixed question of fact and law, right? So for example, let's say somebody has committed assault. Okay, we have an idea about what assault is, but there is a legal definition of assault. So even if you say that somebody smacked another person on the head, okay, that seems to be assault, but does that meet the legal definition of assault? So the point here is that if you say that a particular concept involves a question of law, what exactly is bullying, then you can have a ground for judicial review. So here, it's not a question of that there is evidence of people hearing Olama of having made racist remarks. That is not in doubt. What is in doubt, however, is whether or not those racist remarks comprise or constitute bullying. That is a question of law. Okay, but I will make sure that the question of no evidence is a bit simpler. I'm just doing this so we have a better understanding of this particular topic. You want to go on, or are we done for tonight? I've got a final question. Okay. Okay. Final question. Can somebody read problem 7?
People might be getting sick of my voice. How about Jackson?
All right, I'll have another go. Okay. Fred Smith applied for employment as a federal police officer of the Australian Federal Police. The Australian Federal Police Act requires that a person, in order to be employed as a federal police officer of the Australian Federal Police, must be of good moral character. Sometime after sending his application, Smith received a letter from the AFP asking him to provide more information about previous complaints that he had committed domestic violence and assault against various individuals. Smith provided evidence that all the complaints against him had been dismissed because of insufficiency of evidence against him. He was thus surprised when he later received a letter informing him that he did not meet the statutory requirement that an applicant must be of good moral character. What legal advice would you give him?
Okay. So the crucial point there, thank you, Jackson. The crucial point is that the complaints against him were in fact dismissed because of insufficiency of evidence. What legal advice would you give? Would you suggest, would you advise judicial review? Let me help you with that, if it's okay. I wouldn't advise an application for judicial review, because even if you might say that there seems to be no evidence, because the complaints were dismissed, right? If the complaints were dismissed, we can assume that there was probably no evidence. The problem, however, is that we don't really know what the basis of the decision was. Did the decision make a finding that domestic violence had been committed or that there was assault? We don't know that. Remember, this is an application, so there is no requirement on the part of the decision maker to provide reasons for the decision. No requirement. So you don't know. So how can you now say that there was no evidence to support the decision when we don't know how the decision was made in the first place? The particular case for that is Minister for Immigration and Multicultural Affairs versus Rajamanikam, case decided in the High Court in 2002. So when a decision is made and without a clear statement as to a particular factual finding having been made, so it's not clear, then in that case, it wouldn't be apparent to you what the basis then for the decision will be. And so if you do not know what the basis for the decision is, how can then you now allege that there was no evidence to support a finding of fact? Going back to that question, could you have, since the decision was made under an enactment, could you have used Section 13 of the Judiciary Act to compel the AFP to provide reasons for the decision, so that then you will know why they rejected your application? The answer would have been no. We discussed this last week, right? Because
that you've got no right.
You don't have any right. Because you can only have a right to reasons for decision under Section 13 if you can allege that there is a ground for judicial review under Section 5, but you don't have a ground for judicial review because you cannot say that there is no evidence. It's a chicken and egg thing. You could have said that there is no evidence if there was a decision saying that the decision was made despite an absence of evidence, but you don't know that. So
the other thing in this case, Manjo, was that he's trying to get into the federal police. Surely the federal police can do national federal checks on people, and they would be able to see what the results and the evidence against him were, judging him for poor moral character and saying, no, we're not letting you in.
That's true. That's right. Yeah, true. Okay, so I guess that's it for tonight. Thanks, everyone, for joining this session. There'll be a question in the finals pertaining to the no evidence rule. I'll come up with something simpler, okay? But at least, you have a good idea about the nuances of this topic. So with that, thanks again, and see you next week. Good night. Bye.